Good morning, Chattanooga. I am Trevor Atchley. I'm here for our weekly show, Legal Bytes, and I'm joined this morning with attorney Katie McGregor.
Morning, Trevor. How are you?
Doing fine, Katie. Thank you for being here.
Sure.
And we're attorneys with McCune Williams, Atchley, and Stanley, and we do this show once a week, and we call it Legal Bytes. A byte is, as you know, I'm sure, a small bit of information. And so each week we discuss one or two legal topics for our listening audience. And if you have any questions today and want to give us a call, please do. Our number here is 423-800-8949. And if you want to call somebody at our office number is 423-756-6400. And this morning, Katie, I think we're going to talk about two topics during the first half hour, the probate.
Okay.
And the second half hour, guardianship law. And I get calls a lot of times from prospective clients who are wanting to know a little bit about what happens after somebody dies and how their property passes upon their death. And we refer to that process or procedure of that mechanism as probate. And do you have a fair amount of experience dealing with probate matters?
I have some experience, yes.
Okay.
So it's always I find it a tough area given the emotional nature of the case too, since you're dealing with someone's death and there's always seems to be some family issues there.
Right.
So,
That's, I think for lawyers who aren't involved emotionally, it's easy for us to separate, property or wealth transfer issues from some of the emotional issues tied to those things.
right.
But then for the people going through it, I think it's much more difficult to do that.
Exactly.
And so we're talking about probate. I guess there's, broadly speaking, two types of probate administration. Can you tell us a little bit about that?
Sure. So Tennessee, you can have a testate probate where the decedent has made a will before they die, which we strongly encourage everyone to make a will. It makes things so much easier. And the other type is intestate probate, where the decedent has not made a will or the will is invalid and the property passes pursuant to Tennessee statutes.
Okay. And when it passes pursuant to Tennessee statutes, is that descent and distribution or intestate succession?
Descent and distribution, yes.
Okay.
So the Tennessee law lays out if someone doesn't have a will, Tennessee law says this is how the property is going to pass.
So if somebody wants to have some control over who receives their property upon their death, it's very important for them to have some written instrument, a last will and testament that can be admitted to probate.
Correct. It's very important because otherwise state law will determine. Now, in some cases, there might not be a difference, but a lot of times there's a big difference. And that's where there can be a lot of family discord.
So let's talk about let's say somebody comes in to see you and their last surviving parent has passed away. And we see this a lot, mixed blended family where we have children from different parents.
Mm-hmm.
And I guess that really can be if the person doesn't have a will and it passes pursuant to intestate succession, then you're looking at the heirs at law of the last to die. And that could really almost cut out some of the children of the predeceased spouse.
Right. And it depends too on whether the predeceased spouse had a will. A lot of times in these situations, maybe one spouse makes a will and leaves everything to the surviving spouse, and then that spouse fails to make a will. And so everything goes to, if it's a blended family, everything goes to the surviving spouse's children rather than the first spouse to pass its children, since that spouse left everything to their surviving spouse. So half the family can be cut out in that situation.
And I imagine that creates a lot of controversy.
Just a little.
And so I guess when you're looking at probate estates, from our perspective, as far as advising clients while they're living, you always want to encourage them to put their wishes in writing in a last will and testament, because from experience in probate administration, you realize how big of a difference it can make in how an estate is administered.
Exactly.
So let's talk about the process then of initiating a probate administration. Walk us through the steps.
Well, first, someone will come to me and the decedent will have left a will, and the will will say how they want their property to pass, and we'll file a petition for testate administration, or we'll have one for intestate. Either way, a petition is filed with the probate court in Hamilton County, the Chancery Court. And Hamilton County is a little different because we're required to have representation. Our chancellor requires that probate administrators, the administrator of the estate, the person overseeing the process, be represented by counsel. So that's a little different than maybe some other counties in Tennessee, but that's the local rule here. So we make an appointment with the court to go up and open the probate estate, and we take the person who is either appointed by the will or by statute, that's going to be the administrator of the estate. We go up and have an appointment and open the estate. So that's the first thing is getting it open, and then there are a lot of administrative procedures following that.
Okay. So now you go up and you file a petition with the clerk, and does the clerk issue any type of certificate or any documentation to show that the person is now authorized to administer the estate?
The court will issue letters of administration to the executor or administrator of the estate, or, letters testamentary if there is a will and it's a testate estate. And so letters testamentary are issued to an executor. Letters of administration are issued to an administrator, the person overseeing an estate where there is no will. And those letters give the administrator, the executor, the person in that administrative capacity, the power to marshal the assets of the estate. So they can take these letters to the bank and obtain bank accounts, notify all the possible holders of assets to bring those into the estate. And then they're also required to notify any creditors of the estate as well. So,
okay. Now, does the probate clerk, does it publish any type of notification in the paper for creditors?
If the decedent if the probate is opened within a year after the decedent's death, then the probate clerk will publish a notice in the Hamilton County Herald of the probate, the estate being opened, and direct that any creditors provide their claim and file their claim with the court.
And I guess Tennessee law provides a procedure or mechanism for creditors to file claims against the estate.
Yes. So any creditor of an estate has to file a claim within 4 months of the notice publication, and at the outside they have 1 year following the date of death to file that claim.
Okay. Now, let's say nobody files a petition to open an estate. Can a creditor file to open an estate in order to file a claim against it?
A creditor can. So if it's within that 1 year following the decedent's death, a creditor can actually petition to open the estate so that they can file that claim. And in fact, I've dealt with an estate where TennCare was the creditor that filed that application. So,
okay. And you mentioned something about the personal representative of the estate having a duty to notify creditors. Explain to us what that involves.
Well, when the notice is published, any known creditor of the decedent, the administrator is required to send a notice with a copy of the publication to those known creditors, giving them the time frame in which they have to file the claim and laying out that if that claim isn't filed within that time, then that claim is barred. So they're required to, if they want to be paid, they're required to file that claim with the court.
And is there a procedure? Let's say a creditor files a claim against the estate and the administrator or beneficiary or heir doesn't think it's a valid claim. Is there a procedure where you can contest the validity of a claim?
You can. Once the claim is filed, the estate has 30 days to file an exception to the claim and state their dispute with the claim. And if the claim is, if there's still a dispute, they may come to some resolution, but if not, then a hearing is held with the clerk and master, and the clerk and master will issue a ruling on that claim.
Okay. And who has standing to object to a claim filed by a creditor? In other words, can obviously the executor or personal representative can, I guess, object. Can other creditors object to one another's claims, or can a beneficiary come in and object to a claim?
Beneficiary certainly, yes, can come in and object to those claims.
And so I guess you can get into situations where you have, particularly if a family member files a claim as a creditor, saying, I provided personal services for the care of our mother before she died, and she files a claim against the estate. I guess you can have disputes within the family.
You can, but that becomes difficult with the dead man statute, where that person isn't, the deceased isn't there to testify as to what that agreement was. So if you do, if you make a loan to somebody in your family, we recommend having something in writing for that, so that you can prove it, in the event that that person dies and still owes you money, that you can prove that you have a valid claim, the debt is still owed.
So you mentioned the dead man statute, and just for our listening audience, that's a rule that for anyone who files a claim or a suit against the administrator or executor of the estate regarding a transaction with or business dealings with the decedent, because the decedent there is not available to testify, the law renders that claimant incompetent to testify at trial. The theory being you shouldn't allow the person, the living survivor member in that litigant, the opportunity to testify without the decedent also having the opportunity to defend himself. So unless you either have an independent third-party witness or something in writing where the decedent signed it acknowledging this responsibility or this agreement or obligation to repay a debt, you can have a lot of difficulty establishing your claim.
Exactly.
And so what I find interesting about probate administration is it bleeds into lots of different areas of the law. This is a good example where if you were advising a family on, and they have an agreement within the family where the parents have, or a child has loaned a parent money and the parents agreed to repay it, and it's all oral, knowing the dead man statute implications during probate proceedings would say we need to have something in writing memorializing this agreement. Otherwise, we're going to have great difficulty establishing this claim. Right.
So there are lots of different areas that can be involved in, like we're going to talk about in the second part of the show, the guardianship. If you have minor beneficiaries involved, then, a guardianship can come into play. And so there are a lot of different areas where probate can bleed out.
And let's talk about, does the law provide a hierarchy or a priority for the use of probate assets as far as who gets paid first?
It does. So when all the assets come into the estate, there are the expenses of the estate. So there are the fees for the administrator, the filing fees, attorney's fees. Those expenses of the estate, expenses of administration, the bond payment, those things, those come first, and those are paid first. So if there's not enough money to pay those, then there are some other issues, but all of that is paid first. Then creditors and claimants are paid. So any valid claims that aren't disputed, those get paid. And then before that, all taxes have to be paid. And then finally, the very last on the list are the beneficiaries. So after everything, all the debts have been paid, the expenses of administration, funeral expenses, all of those things. After they're all paid, then the assets can be distributed.
And you may have mentioned this, I may just have missed it. Where do funeral expenses fall in on that priority?
Funeral expenses fall in under the administrative expenses. So they're paid first.
So they're one of the top priority expenses to be paid.
They are.
Okay. So if somebody came to see you and they're worried about, their parent has died and they're worried about having to pay the funeral expenses, you would be able to tell them that's assuming there's sufficient assets coming to the control of the executor or administrator, reimbursement of that expense would be one of the first things to be paid.
Correct.
And now, it sounds to me like this is a fairly involved process. So we have a publication that goes out to creditors where they have 4 months from the date of first publication within which to file a claim against the estate. So I guess the probate must be open at least for that 4-month duration.
Probate has to be open. We keep it open for at least a year so that you have that full year timeline for the creditor to file, because we don't want to close an estate and then have a creditor come saying, I gave notice as an unknown. That would be an unknown creditor.
I've actually dealt with that issue before, not actually having had a creditor file a claim, but there's a provision under our law where you can close the estate at the 4-month date of the first publication to creditors with approval of the court. And the question always arises, what happens if an unknown creditor comes forward? And what the law provides is if the creditor files its claim and it's a valid claim and it's upheld, then each of the distributees, the beneficiaries who received money, is liable to pay that debt on a pro rata basis.
Yeah.
Of course, by the time somebody gets their inheritance, they normally don't hold on to it very long.
I was going to say, I imagine that there is not much left in that situation. That's why we like to keep them open, at least for that period, even when things are, everything's all taken care of, just so that that situation doesn't happen. Also, it tends to be a fairly involved and lengthy process. So when we can close an estate that fast, that's great. But usually it takes a little longer, given all the steps and all the notifications that have to happen. And it's just a longer process, unfortunately, and clients don't always understand.
Right. And in my experience, the people who are the distributees, whether it's testimony of beneficiaries or heirs at law, tend to want to get their distributions as soon as possible.
Well, of course.
Now, so if you're advising the executor or the administrator, your objective there obviously is to make sure that they've administered the estate correctly. And so you're going to, I guess, from what you're saying, you're going to encourage them to withhold making final distributions for at least a year so that that there's no claims of creditors that can come forward.
That's correct. We want to make sure that there is enough in the estate to take care of any valid claims that may come up. So, and since they're paid before beneficiaries, we want that taken care of.
And if an executor or administrator didn't listen to your advice and may just, let's say they know about a creditor and they just, against your advice, decide not to pay that debt and instead use the estate assets to distribute to family members or abscond with the money themselves, can that person be held personally liable?
They are personally liable. So when an estate is opened, depending on the circumstances, a bond actually has to be filed to cover the value of the assets of the estate or the estimated assets of the estate, what's known at the time of filing. And so in the event of intestate administration, a bond will have to be filed to cover those expenses. However, a decedent could waive the filing of a bond in their will. And so in that situation, if someone dies with a will, an executor is appointed, bond is waived, and then they take off with the money, they're personally liable. So it's a big responsibility.
Sounds like it. And so the executor, that presumes there's a will. Mm-hmm. And this is somebody that the person who created the will, the testator, obviously had a lot of confidence in, and they nominated that person to serve in their will.
Right.
In the situation of an administrator, this is somebody that's either on the hierarchy under our statute as first preference to serve, or somebody just appointed by the court to serve.
Correct.
And So we're talking about, okay, we got the notice to creditors, we got the 4-month time period. How is real property treated? How is real estate treated?
Real estate falls outside of probate unless there aren't sufficient assets to pay the debts of the estate, to pay the expenses and the claims of the estate. And then a motion has to be made to bring that real property into the estate and sell it in order to pay for the expenses and claims of the estate.
Now, in a will, can a person provide a specific provision giving the executor authority over real property?
Yes, they can.
But the standard rule is that real estate title to it vests automatically either in the beneficiaries in the will, if there's a will, or in the heirs at law if there's not a will.
Correct.
Okay. And so if there's not enough money available to the personal representative to pay those higher priority claims, then they have to ask the court for authority to sell that real property.
That's right, because it's not automatically a part of that testated estate unless it's set forth, unless there's a will and it's set forth in the will that it is a part of the estate.
That's very interesting. And what happens? Okay, so let's say we've had to petition the court to sell the real property, and the real estate's sold. What happens to the proceeds?
Well, the proceeds then come into the estate, and they're used to pay all those claims and expenses of the estate before any distribution. So even if there are beneficiaries waiting to receive a distribution, all the debts of that estate have to be paid before any funds are distributed.
Okay. And let's talk about now, so we've gone through the process, we've notified creditors have filed claims. We're at the year where we're ready, I guess, to wind up the estate.
Mm-hmm.
And let's say we're ready to make distributions. Let's say one of the heirs at law is a minor child. Can you make distributions directly to that minor child?
You cannot. You have to, depending on the amount of the distribution. If it's $10,000 or less, you can make the distribution to their legal guardian, their natural parent. However, if the distribution is more than $10,000, you have to petition the court and actually have a legal guardian appointed to receive those funds.
Now, if a person died with a will, I assume they could provide provisions in the will that any child's interest would be held in trust for their benefit.
Correct. You can have that done, but in the event of an intestate estate, then you have to have a guardian appointed to receive those funds.
And that's actually going to be our next topic. The next half hour is talking about guardianship law and how you get that process started. So that could be would the executor or administrator in that circumstance have a duty to ask the court to appoint a guardian before they distributed money?
They do. They have to have, they don't have to be the guardian themselves, but they do have to see that a petition is filed.
And I'm assuming there would be additional costs incurred in establishing that guardianship.
There are filing fees, additional bonds that have to be paid, and all of that things, which we can get into in the next half hour when you tell us about guardianship.
We'll talk about that next. We'll see you on the other half of the break.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Chattanooga cops say an attempted rape of a minor was live streamed on Facebook. 2 people have been arrested. Tyasisa Robertson, who's 19, charged with the filming, and Sherman Hubbard charged with the act of the attempted rape. The police say a friend saw the live stream and rushed to the scene to get her friend out of there. The victim, who's not named because she's a minor, says she was forced to the floor while one man filmed and multiple men watched. Philip Andrew Forrester was indicted by a federal grand jury on child pornography charges, but before the FBI could arrive to arrest him, he shot and killed himself. Forrester was found dead by the FBI in his mother's home in Tullahoma, but they didn't leave empty-handed. They seized digital media, DVDs, even floppy disks from the home. City Councilman Ken Smith is to hold a press conference on Thursday at 11 a.m. regarding the fixing and paving of North Point Boulevard. It's a private and publicly owned road serving as a main thoroughfare for residents and visitors. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect lots of sunshine, hot and humid weather out there through your afternoon. Mainly dry, high soaring into the lower 90s. Tonight, fair but muggy lows into the lower 70s. For Thursday and Friday, continued hot and humid. Just a slight chance of a spotty shower storm. Highs lower to middle 90s. Check out Little Caesars, where you can enjoy a large classic pepperoni pizza for only $5. It's hot and ready all day, every day at Little Caesars, plus tax at participating locations. And I'm Smorsheen 12 Chief Meteorologist Patrick Orr on Nooga Radio AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal, providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune, Williams, Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
This is Thomas DeMoss with Keller Williams Realty. I am a realtor in Chattanooga. We list and sell homes, work with buyers, work with home sellers. I have been involved in real estate for over 10 years. My background is as a real estate investor. That is what I bring to the table, is that real estate investor mindset. My job is to help you sell your house for the most money, employing the best marketing strategy and walking you through what can be a rather stressful process. So we are encouraging people who are on the fence or even thought about selling their house to give us a call. There's no obligation. We're just here to kind of have a conversation, let people know what the process is like, what the market is like, what values they can expect to receive. We work with buyers as well. I also have a buyer's agent that works exclusively with my buyers because we want to give our clients as much attention as we can. My cell phone number is 423-364-0028. Our website is northriverpropertygroup.com. That's northriverpropertygroup.com. We'd love for you guys to call us.
I have the best steak selection in town. The name of the business is Don's Meat Shop, and I'm Donnie Raines. Just ask for Donnie. I make over 20 different types of sausages. Most of them are great for grilling. We have the best selection, best quality. We have the hard-to-find items. Don's Meat Shop.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Hello, everybody, and welcome back. This is the second half hour on Legal Bytes, and I'm Trevor Ashley. I'm here with Katie McGregor. If you have any questions, please give us a call. The number here, 423-800-8949. You can also always reach us at our office at McCune, Williams, Ashley, and Stanley, 423-756-6400. And I'm here with Katie McGregor, and we're in the first half, we talked about probate. And in the second half, we're going to talk about guardianship law.
Yeah. So Trevor, we talked some about probate and a little bit about how that can bleed into other aspects. And we were talking a little bit about guardianship, how guardianship might come up in the context of a probate. You do a fair amount of guardianship work, right? So you're pretty...
We do. Yeah, I'm fairly well versed in that area of the law.
Okay. So what are the various situations that you've had a guardianship come up? I mean, I know there are some, like we talked about, where probate, where a minor's receiving funds that you know, that are there. But what are some of the other ones that you've had?
So normally it comes up in the context of a child's parents are deceased, and the court needs to appoint somebody as legal guardian for the child in order not just to manage or hold their money. They may not even have any money. They just made somebody appointed that would then have legal authority to make decisions resident for that child, whether it's residential decisions or medical decisions, or whether they're going to attend school. And so generally, at least in the guardianship we're talking about, is typically where both of the parents, natural parents who are under our law, the natural guardians, are deceased or some reason not available to take care of the child. There's also a guardianship proceedings which you can have in juvenile court where a child is dependent or neglected. But what we're talking about here is something, an action you would file in chancery, where you're asking the court to appoint a legal guardian to make medical, their person, which is make medical decisions, residential decisions, or over their property, like we were talking about in the context of a distribution from a probate estate.
So in that context, when you need to have a guardian appointed for a child who's both of their natural parents are deceased, can the parents make provisions for who they want to be appointed as guardian before the child, or what, you know, how they want things to be done before they die? Is there something they can do?
Absolutely, yes. And the parents can nominate in a will guardians to serve in the event that they both pass away before the child reaches the age of majority, which in Tennessee is 18. The way the statute's written, it's written very broadly. So the court would look at any writing from the parent where they've nominated a guardian, but you typically see it in the last will and testament, which of course is probated and becomes a public record, and is a very strong statement from the parents stating, this is who I want to serve as a guardian in the event we're not able to.
So if the parents name a guardian in the will, do you still have to go through a process to have them appointed, or because it's named in the will, they're automatically that child's guardian?
That's a great question. No, it's not self-effecting. You still have to file, again, like when you start a probate, you have to file a petition with the court. So it's the same thing, very similar here. You have to file a petition with the court, essentially telling the court who the child is, identifying the child, and the circumstances which necessitate the appointment of a guardian, and ask the court then to appoint a guardian. The court will give strong deference to the nomination in the will, whomever the parents nominated to serve. But even that's not determinative. The court will do what it thinks is in the child's best interest.
Okay. So in the situation, let's say parents name a guardian, does the court, I guess are there issues if the parents name someone, say, outside the family to be their child's guardian? Have you had that situation where, you know, a family might contest? Can someone contest that appointment, or are there people that are notified when that petition for guardianship is filed? How does that work?
Yes, that's another great question. The short answer to that question is yes, that does arise. And we also do some estate planning practice. And in my practice in that area, one of the most difficult decisions parents struggle with is, whom do I nominate to serve as a guardian?
Mm-hmm.
And it can be the exact hypothetical you just posited there, where they have family, but they don't really feel comfortable with any of the family members serving as the guardian. And so they nominate maybe a close friend, or, you know, obviously it's somebody they're very confident in and have trust in. So it's normally a close friend or acquaintance. And under our statute, when you file a petition, you have to notify all the child's closest relatives, which would be his heirs at law, which would be, in this case, his parents are deceased, so it would be his siblings.
Mm-hmm.
And they would all get notice of the petition. And the interesting thing that happens is this can occur where the parents have nominated somebody to serve, and say it is outside of the family. So under our statute, that person is the preferred person in the hierarchy, priority to serve. But the other family members can come in and contest, and they can say, because it is subject to the determination by the court and what's in the child's best interest, say, Your Honor, I don't think this appointment's in the child's best interest. We think one of us should serve, or some impartial third party.
Okay. So what factors does the court consider when they're determining whether an appointment is in the child's best interest?
Well, there's not. So in like some child custody cases, for example, there's the legislature has promulgated a list of non-exclusive factors courts consider when looking to see what's in the child's best interest. Our guardianship statute does not provide that type of enumerated list.
Oh, really?
But I would think that the court would at least consider those same factors in making a determination. And ultimately, it's going to be things like, is this person going to be able to make decisions in the best interest of the minor child? Is this person someone who has a good, for example, credit history and can manage the child's money well? Is this somebody who is going to always put forth the child's best interest as opposed to perhaps using the minor's funds for their own benefit or something like that?
Okay. Okay. So what happens? We filed our petition. The court has determined that the guardian that, let's say, the parents nominated is going to be able to serve in the child's best interest. What happens now?
So the court then will appoint, it can be either over the child's person, that is the person to make medical decisions, residential decisions, whether the child will attend school, or the person can be appointed only over the property, which would be to hold legal title to the child's funds as guardian for the child, or the court could appoint that same individual in both capacities over the person and property of the minor child. And under our statutes, if you're appointed guardian over the minor's funds, you'd be required to post a bond, a fiduciary bond, and file accountings with the court of how the money is used for the benefit of the minor child.
How often do you have to file those accountings?
So the first accounting is due 6 months after your initial appointment,
Okay.
and then annual accounting is required every year thereafter.
Okay. Okay. Is there, so what if a parent, you know, the parents are deceased and they make provisions for a trust in their will? How does that operate within the context of the guardianship? Is that separate, or is the guardian appointed over those funds? How does that work?
That's another good question. The testamentary trustee would hold legal title to any funds that pass under the will.
Okay.
For the benefit of the child. And that would be totally separate. So you would not need a guardian of the property, and that, assuming that's the only property the child's entitled to, under that hypothetical. You still, though, would need a guardian over the person to have someone to have legal authority to make medical decisions for the child, for someone to have legal authority to make residential decisions or where the child's going to attend school.
Okay. Okay. So what other situations have you had to deal with a guardianship? You know, we've talked about this where the parents are deceased and a guardian has to be appointed for that minor child. What are other situations? Do you deal with the dependency and neglect?
I have. That's not a big focus of my practice, though. That is under our statutes. Juvenile court has original jurisdiction, and then, of course, that flows into circuit court. And the type of guardianship we're talking about is typically filed in chancery court. I think you are allowed to file in circuit under our statute, but under our local rule, all guardianships should be filed in Part 1 of chancery court. And we have a whole division in the clerk and master's office that's just set aside for guardianship and conservatorship cases. And so the clerks there are very knowledgeable about all the accounting requirements and the steps you have to go through in order to have a guardian appointed. I will say sometimes even when a child's parents are living, you can still have a situation where you have to have a guardian appointed because the child becomes entitled to funds in excess of $10,000.
Okay. So tell us a little bit about what happens in that situation. Is the parent automatically the guardian, or you have to have someone actually appointed?
You have to have somebody appointed. The typically arises in the context of life insurance.
Okay.
Where someone, you know, an aunt or an uncle has named this child as the beneficiary in a life insurance policy. This is a good example. And the aunt or uncle dies, and the life insurance company needs to make its distribution to the named beneficiary, which is a minor child. And let's say the child's entitled to $50,000. Well, a parent and natural guardian can hold up to $10,000 without having to be have been appointed by the court. But anything above $10,000, you're required to have court supervision. So in that circumstance, the parent would have to file a petition with the court to be named guardian of the property in order to file application with the insurance company to receive the life insurance proceeds.
Okay.
And all the same rules would still apply. You'd have to, under our statutes, there's a hierarchy for who serves, and of course it's the closest relative, so it'd be the parents first. And if in our hypothetical there, the parents are there, and so they can serve.
Right.
and the court will still require a bond, and the court would still require all the accountings, and you essentially go through the same exact process, except that instead of a third party serving, you have the child's parent serving in that capacity.
Okay. Is there any way for the parents to avoid paying a bond? I mean, it's their child and, they're going to hold this money for the child. Is there a way to avoid the bond? Because depending on the amount of funds that are coming to the child, the bonds can get pretty expensive.
Well, there's two issues there. That's correct. The premium can be very expensive. And two, sometimes the parents' creditworthiness isn't fantastic and they can't qualify for a bond. So the alternative there is you either pay the money into the registry of the court and the clerk and master holds it, or you set up an account with some type of financial institution, whether it's going to be, just a bank, or if it's going to be an investment bank, where you enter into an agreement with a financial institution, which is approved by the court, where there's a no withdrawal agreement, where the financial institution agrees to hold the money, but not to allow the guardian to withdraw any money unless it's authorized by court order.
Okay. So what happens if, this guardianship has been continuing for a few years and something happens and the child has significant medical expenses, and the funds are being held by a bank with this no withdrawal order? Is there something that, let's say in this case, the parents are still living, it was, the child's uncle that left them life insurance proceeds. Is there something the parents can do to obtain money, or what?
Yes.
What happens?
You would file a motion with the court and ask the court to authorize the disbursements from the minor's funds for this medical care. And what this can actually create, though, an interesting conflict question, because assuming the parents are still living, the parents have a legal duty to support their children, and providing necessary medical care is a legal duty of the parent. And so what we're proposing here is the parents are asking to use the minor's funds to pay for his own care. There's a question of whether they're trying actually to avoid their legal duty of supporting their child by using the minor's funds, when they should be just a natural duty of the parents to do that.
Right.
If this is some extraordinary expense, or if they have a child with special needs or something, obviously the court would take all that into consideration, but the court would first want to make sure that the parents truly don't have the resources to pay for it, and they're not just trying to avoid their legal duty of supporting their child.
Okay. What if, can those funds be used? What if the child turns 16 and decides they want a car? Can they petition to get those funds to buy a car? Or
Yes.
is that considered a duty of the parents to?
Well, anytime a parent was serving as the court-appointed guardian, you're always going to run into that conflict question. And the court's analysis is always going to start with, is this truly something we need to use the minor's funds for? Okay. But to answer your question, yes, generally speaking, the minor's funds can be used for anything that benefits the minor child, whether it's paying private school tuition, or whether it's purchasing them an automobile, gifts. I mean, it can be anything that benefits the child, and it's just you have to ask the court for permission before you make that disbursement.
Okay. But now if the parent in this situation, let's say it's the same one where the parent is the legal guardian, if the parent is holding the funds, paying that bond premium, they don't have to get court permission to spend the funds, or are there guidelines that say what they can spend those funds on for the minor child?
That's a great question. So when you initially open up the guardianship, and the parents, paid the bond premium, and they've actually received the money, it's in a bank account, the parents have to file what's called a property management plan, which sets out how they anticipate to be using the minor's funds. And that can be for, private school tuition, things of that nature. And the property management plan is actually submitted to the court for approval. And the court approves the property management plan. And as long as the guardian is making expenditures and disbursements consistent with that court-approved property management plan, they don't have to ask further request for approval from the court. But if there's some extraordinary expense, then the guardian has to either ask the court to approve it in advance, or go ahead and, if it's an emergency situation, go ahead and pay whatever it is, and then file a motion with the court and ask for ratification.
Okay. So what happens if they if they pay that emergency expense, but then they don't ask the court to ratify that expenditure, what, and then they go to do their annual accounting, what happens? Does the court have any powers of, I guess you would say, maybe discipline, or what can they do?
Well, if the court ultimately, that's a great question. Yes, it would show up on the annual accounting. And when you file an annual accounting, you have to support it with original monthly bank statements from wherever the minor's funds are held. So there's, you have to come clean at that point in how you've used the minor's funds.
Mm-hmm.
And the court's going to hold a court-appointed guardian to the strictest fiduciary standards. And if there's an expenditure which wasn't approved by the court, wasn't ratified by the court, and is not consistent with the property management plan, then the court has a couple of options. One, they can hold the guardian personally liable for that expense. The court could at that time consider it and determine whether to ratify the expenditure, or the court could say you've breached your fiduciary duty. One, you're personally liable to pay the minor's funds back, and two, you're not going to serve as guardian anymore.
Okay, so the court can appoint a new guardian if they believe that this guardian's not acting in the best interest of the child anymore.
Absolutely, yes.
Okay,
and that's just the prerogative of the court. If the court decides that is appropriate.
Okay, so the court can just decide that on their own. They don't have to have someone else come in to petition.
The court can do that on its own initiative. Typically, though, it's initiated by a petition.
Okay. What happens if, we talked about this in the context of a child receiving an inheritance. Both their parents are living and they've received some type of inheritance, over $10,000. What if they get a gift? What if grandma and grandpa want to give the child money? Does a guardian have to be appointed for a gift? How does that work?
Well, it would normally, in that circumstance, you would think the grandparents would probably establish a trust
Mm-hmm.
To hold, where the trustee would hold legal title to the funds for the benefit of the child. But the grandparents are making a gift there is a Uniform Transfer to Minors Act, which they probably would utilize, where you don't have to have a court-appointed guardian, but under our statutes there, you have essentially a custodian appointed under this Uniform Transfers to Minors Act, and that custodian holds legal title to the proceeds for the benefit of the child. So there's a whole separate procedure there where you can establish the gifts to minor children without having to have a court-appointed guardian.
Okay. So this is going back a little bit. You mentioned a conservatorship. What is a conservatorship, and is that different from a guardianship? You mentioned conservatorships and guardianships together. I'm just trying to get a little distinction.
It is. A guardianship is a court-appointed fiduciary where you have a minor child. And a minor child is legally incompetent to make his own decisions or manage his own property because of his age. A conservatorship is a court-appointed fiduciary for an adult. And the threshold issue in those is whether or not the person actually needs court intervention or not. When you have a minor child, obviously it's necessary because the child they're not emancipated. They're not legally capable of making their own decisions.
Okay, so conservatorship is a whole separate issue from a guardianship, completely different.
It's similar to the extent it's a court-appointed fiduciary, but it's exclusively for adults, and guardianship under Tennessee law is exclusively for minor children.
Okay, I understand now. So going back to the final accounting or the annual accountings, what happens when the child turns 18? Is it automatically dissolve, or?
Well, the guardianship can be extended to age 24 by motion.
Okay.
But typically, otherwise it would terminate. Yes.
Okay.
Listen, everyone, thank you very much for listening to our show this week. This has been Legal Bytes. Trevor Ashley and Katie McGregor, and we'll see you next week.